This past week has really been Voting Rights Week and Supreme Court Week on this channel. And if that's not your thing, I apologize. It's going to continue because I just have more thoughts. And I'm obviously writing about all of this. And so since I'm going to be writing about this, I'm kind of thinking about it, it's all in my head. Next week, at some point, probably Monday or Tuesday, I'm going to do a video actually just explaining the Voting Rights Act, going through both the history of voting rights laws, stretching all the way back to the 19th century, the particular history of the Voting Rights Act, what it did, since it's for all intents and purposes dead, what it did, why it was significant, what its effects were, what the likely effects of its destruction are going to be, and sort of where to move forward from there, and what areas to look at in terms of political action, which of those areas are going to be most significant moving forward. In thinking about all of this, I've also just been thinking about this Supreme Court, the Roberts Court, its larger jurisprudential agenda. And I don't want to give too much credit. I think you can make a very good case that what we're seeing is mostly just the actions of a bunch of Republican partisans, and they want to make sure that the Republican Party does all right in elections. They do have their particular idiosyncratic interest, and John Roberts and Sam Alito in particular have always seemed almost aggrieved by the existence of the Voting Rights Act. John Roberts, the young lawyer in the Reagan administration, was very much opposed to the congressional bill that strengthened Section 2. And this recent ruling is basically Roberts and Alito similarly opposed to that, rewriting Section 2 to be what they think it ought to have been to begin with, which is to say a nullity. They've always had this grudge against the Voting Rights Act, always seen it as terribly intrusive, as unfair. Alito in particular is very much on this kick that it's unfair to accuse people of racism. That practically is as bad as racism itself. Not for nothing, Alito joined a group that opposed the admission of women and minorities to Princeton, so he might be a little sensitive about this. And so that's their idiosyncratic, right, like own views. There is clearly an agenda with regards to aggrandizing presidential power, as I've said before. You have someone like Clarence Thomas, who is very much this, misanthropic figure with his own strange ideas. So that's not to, it's both the case that there are maybe more interesting things going on with some of the justices, and also true that in a lot of ways they're functionally Republican partisans. But if you're so inclined, there is a story you can tell about what this court is doing. Before the Civil War, as I'm sure you know, states in this country were really the locus of power. The federal government was not weak, and this is a common misconception, this idea that the federal government was exceptionally weak, didn't really do much. That's not really true. But it is true that it was not nearly as large in its scope as it is today. And it is true that there wasn't the kind of immediate federal supremacy or deference that we experience today. Rather, the federal government and the states sort of had overlapping spheres of influence. And a lot of the jurisprudence of the era is an attempt to kind of delineate where the federal government's sphere of influence dominates, where the state governments do, where the local governments do. It's interesting stuff, but that's a general picture of federalism in this period. And the states really are extraordinarily powerful. And in particular, they have wide-ranging what's called police powers. The idea is that a state's police powers are its power to use the word, to police its internal affairs. And that's police in almost all senses of the word. That's police in terms of public safety and law enforcement. That's police in terms of who was allowed into the state to begin with. So plenty of states in the Antebellum era had prohibitions on the migration of Black Americans into their states. There's a great book by an historian, Kate Mazur, about this. Here it is. That if you want to read more about this dynamic, I really recommend it. States could forbid who comes in. They could explicitly forbid pauperism, right? Just being poor. States had control over citizenship, right? You were a citizen of your state first and foremost before you were a citizen of the nation, or rather state citizenship was sort of the dominant and most important form of the citizenship, and national citizenship was sort of ill-defined. And there are a number of great books about the quest to define national citizenship, which was really a product of Black Americans and abolitionists who insisted that there was a equal national citizenship and that it included people such as Black Americans and the enslaved. I'm going to recommend a somewhat older book just in the last 10 years from my friend Martha Jones on the subject, as well as a very recent book by my friend Anna Law on the subject. Highly recommend you check them both out. And most critically to our discussion right now, police powers involve the power to structure electorates, determine who had the right to vote, and the circumstances under which they did vote. What the Civil War did, and in particular what the Reconstruction Amendments did, by establishing clear prohibitions on certain kinds of voting restrictions, for example, the 15th Amendment says you cannot abridge the right to vote on the basis of race, and the 14th Amendment establishes the equal protection of the laws and due process of the laws for people in all states, as well as the privileges and immunities of citizenship. What those things do is to create a minimum federal baseline, right? There is a floor beyond which you cannot go below when it comes to structuring the internal affairs of a state. In subsequent jurisprudence, especially in the 20th century, the rights expansion of the 40s, 50s, 60s, and 70s further establishes baselines below which states cannot go. And this is important because states were often not the laboratories of democracy as the cliche goes, but laboratories for autocracy. That's what Jim Crow was, for example. Chinese exclusion in the 1880s had its roots in efforts to expel and exclude Chinese Americans from Western states. So the court in the 20th century does begin to establish these floors for rights. A floor for a right to privacy, a floor for a right to an abortion, a floor for a right to an education, I think through Brown v. Board of Education, a floor against harmful or invidious discrimination on the basis of race or sex or gender, so on and so forth. And one way you can look at this current court, the Roberts Court, this court which is the product of a 50-year effort by the conservative movement to capture the court and turn it into an engine for its own interests, one way you can look at this court is an attempt to tear up that floor, to eliminate that floor, to say that there is no longer a national floor for rights, and rather that the full scope of your rights, from your right to vote, from your right to get an abortion, from your right to travel and move freely, all of these things are structured by the states, and that the federal government cannot really intervene. Now, I'll note that let's say you're a state and you want to make sure that there's gender-affirming care for transgender youth, the courts might not be too happy about that. Let's say you want to regulate gun rights. The courts may not be too happy about that. So this is not really a full expansion of police powers for states to do whatever they please. Rather, it is establishing for the rights that the conservatives view as most important a minimum floor. And that's sort of gun rights, rights of property, a vision of free speech in which money equals speech and there are no limits on speech and thus no limits on money, and a very narrow and exclusionary vision of religious liberty in which religious liberty means the right to discriminate against people on the basis of religion. The court wants to establish a floor for those rights, but then for anything that might enable human flourishing, that might enable people's ability to live their lives as they see fit, which might enable people to challenge existing hierarchies, whatever it is, the court is saying no more, no minimum floor. And so if your state wants to obliterate effectively your ability to get representation, it can't. If the state wants to obliterate effectively your right to bodily autonomy, you can't. And your freedom, such that it is a freedom to move, right? If you're fortunate enough, affluent enough, capable enough, able enough to move to a place where those rights are a little more secure. But then this interacts with the court's jurisprudence when it comes to the presidency. And so in addition to this, they create a situation where the executive branch, or at least Republican-led executive branches, can do whatever they want. And so it's sort of a catch-22 if you believe in rights that extend to ordinary people and aren't just excuses for the wealthy and the powerful to dominate the rest of us. As I look at the camera here, I've almost been talking for like almost 10 minutes. I know when I edit it, it might be a little shorter. And this is why I wanted to bring this into a separate video, because I might discuss some of this stuff next week in either my piece or in the video I'll do about the VRA. But this is me thinking out loud, and I wanted to share this observation with you because I think it's useful and I think it's something worth dwelling on. So I'll see you next week with a video on the VRA, with a column on the past week of events, as well as maybe some version of what I've just explained here, some version of what the court is doing, and then we'll go from there. Have a nice one.